But when you're speaking of lawfully detained, you're referring to some question as of a criminal nature.
Yes, sir.
Okay, so not some, for example, not some student that may be lawfully detained on campus for whatever reason. I just want to make sure that I understand the intent.
Yes.
Okay.
The intent is
tied to some sort of criminal.
If probable cause exists, if there's there's a criminal offense. I'm investigating a criminal offense.
Okay. The other thing too, the bill on page 1 talks in terms of may not adopt a policy, may not prohibit a person employed. Let me put on the hat of a mayor or a city council person, and let's just say you have a police force of, let's say, 5,000 people. Let me just pick Houston Police Department.
Just for the heck of it.
Right, just for the heck of it. Suppose you have officers who now read HB 12, and it says that a bill may not adopt a policy, a bill may not prohibit. And you have, let's say, police officers who decide that they want to make all of these inquiries into a person's status. And it takes up a lot of time by that police officer. But he is questioning a person who has been lawfully detained and start going through all of these different inquiries. As a management, I'm on the side, and my questions are dealing with management now.
Oh, okay.
Okay. Does that police officer under HB 12 have the authority from the state of Texas now, irrespective of time management locally? Does that police officer now have the authority by HB 12 to take as much time as he or she desires to inquire into the immigration status of a person?
It empowers police officers to use their discretion. That's what the bill does.
Okay, I'm just asking.
Yeah.
So, what about police officers now is inquiring into the immigration status? Police officer now wants to take the time to send the information to.
They have to have some probable cause. I mean, at the end of the day, you're sitting there. You know, I'm not Mr. Criminal Lawyer. I don't practice in the criminal courts. Some that you may have, and Mr. Pena and others may have done that. But at the end of the day, inquiring into you're lawfully detaining somebody for the issue.
Mm-hmm.
They're generally police officers, in my experience, in the city level anyway, is that they're basically inquiring about the offense. But there may be something that comes up, probable cause exists, that they want to use their discretion and find out. If that's the issue. And I understand what you're saying about you're getting to the implementation.
Let me finish my train of thought.
Okay.
Police officer stops a person and lawfully detains a person, inquires about the immigration status, receives information from that person, deciding that they want to follow the process all the way through to make sure that the information gets to wherever it needs to go. So the police officer now makes the lawful stop, does the inquiries, wants to send information to the United States Immigration and Customs Enforcement, wants to maintain the information, wants to make sure that this information is exchanged with another federal, state, or local government entity, wants to assist the feds in this immigration processing. All of this, the bill says that the city cannot prohibit an employee or an officer from doing. From a time management, local time management, can that police officer say to the city council, to the mayor, you cannot stop me from doing all of these things, irrespective of how much time it takes or if it takes me away from going and checking on another crime. I have the legal authority to do all of this.
The only way I really know how to answer that is I think the city of Houston or any police department, if this bill were to pass, would probably look at their processing and rules and how they would, if an officer wanted to do that, to try to ensure that it was the best and most efficient use of their time.
And that's the point that I'm making. Even though the bill says that it may not adopt a policy and it may not prohibit a policy, conversely, the bill is forcing the cities to adopt policies in order to keep this from being from having unintended consequences.
Well, I think they would adopt policies, I would hope, that if they needed to in the police departments to ensure that they have the processing abilities to go ahead and making sure that the officer's best use of their time if it comes up. I don't really know any police departments or officers that are not going to want to. My experience has been most officers want to get in and get out if they have to book somebody. But at the end of the day, the way it most likely would work, and I would defer to people maybe in the police departments to some degree, but what I've seen over my years in that arena is that, generally speaking, the officer, if they are going to suspect something at that point in time from their lawful detention, are at that point probably going to arrest the person and bring them down and book them. They want to get in and get out as fast as they can.
Right. And the only thing,
but they're not going to sit there on the street for 10 hours trying to figure this out.
Well, I understand that, but as a legal matter, and in terms of passing a policy on the state level, what HB 12 says legally is that if an officer chooses to stop someone legally, that officer now has the state authority, irrespective of local management rules and guidelines,
To do their job.
Not just to do their job. The officer has the legal authority to inquire, to take the time to send the information to wherever the officer thinks the information needs to go, to maintain the information, to exchange the information, to assist. This officer, by virtue of HB 12, is given the authority to say to the police chief, to the mayor, to the city council, I don't care how much time it takes, you cannot stop me from doing this. That's what HB 12 says. Because HB 12,
I think it does.
Because
I think it does empower the officer to say you can't adopt policies to prevent me from trying to enforce the law that I'm sworn to uphold.
And that's precisely the point that I'm making. You're telling the city hands off, and HB 12 specifically outlined the things that an officer can legally do, irrespective of the time management that it may take away from doing other duties in that city. It gives each individual officer the authority to say, look, I have legally, as long as you legally detain somebody, that officer can take as much time as he or she desires to do all of these things, irrespective of what impact it may have on their law enforcement duties as a whole to any particular city or locale. That's my concern, not on all these other issues. I'm simply, if I were a mayor, if I were the mayor of a city, okay, I would say to you, I understand what you're trying to do. I understand what y'all are trying to do, but you all are making it very hard for me to run my city, because I don't need 100 officers on the street coming to me saying, Mayor, police chief, you cannot stop me from doing this. You all may not want to do it, but the state has given me the authority to do this. And if y'all don't want to do it, you can't put in place any policy to stop me. We're going to do it anyway. Now fire me.
Then you got a whistleblower wrongful termination.
And if you try to fire me, I'm going to go to the governor and I'm going to have all your grants pulled away. That's the point that I'm making. When you tell localities what they can't do, and you prescribe certain rules to what an individual can do, I think you set it up for unintended consequences from a management perspective. I'm not concerned about all these other issues, but I know if I were mayor or city council, I would be concerned.
I can understand that.